Every incident writes a unique narrative. Every investigation seeks objective facts. Securing your legal rights, uncovering real justice.
Sir, I'm gonna need you to move to economy.
What? This is my seat.
First class is for certain tickets. You're in the wrong section.
My boarding pass says 2A. You scanned it.
I don't think this is right. People don't just end up here.
Oh, so you think I can't afford the VIP? Call your supervisor.
Why?
Because you're about to make this real expensive, buddy.
He had purchased that first-class seat 6 weeks before the flight. It had not been an impulsive purchase or a last-minute decision. It had been planned with the advanced preparation of someone who travels frequently enough to know that the price of a first-class seat on certain routes is worth what it costs when the alternative is arriving at an important meeting after 8 hours compressed in an economy-class row. He had chosen the specific seat on the app, had received the confirmation by email, had checked in online the night before, and had arrived at the boarding gate with enough time to board on the first call. He had done everything that any other first-class passenger does when they buy a ticket and intend to use what they paid for. And then a flight attendant appeared beside his seat and asked him to stand up. The phone in his jacket pocket began recording before he had fully processed what was being asked. That reflex, picking up the phone and documenting when something that should not be happening begins to happen, had become common enough among enough people that the world had accumulated over recent years, a growing archive of moments that would otherwise exist only in the memory of those who lived them and in the institutional version of those who caused them. This specific video, recorded in a first-class cabin while the plane was still on the ground, with passengers boarding around it, would become part of that archive in a way the airline had certainly not calculated when the flight attendant made the decision she made. The man sitting in that first-class seat was named Marcus. He was 38 years old, was a senior financial consultant at a firm with offices in 4 countries, and had accumulated over 12 years of career, a level of experience with air travel that most people never develop, because most people do not spend their lives inside airplanes the way he did. He knew boarding protocols, knew passenger rights, knew the difference between a request that has a basis in some operational rule and a request that has no basis beyond the decision of whoever is making it. What the flight attendant had asked him to do, stand up from the seat he had purchased and paid for without any explanation that held up, was clearly the second category. And Marcus knew that with the precision of someone who had spent 12 years learning the difference. The flight attendant had arrived at his seat with that specific posture of institutional authority that exists in uniformed professions, the posture of someone who represents an institution larger than themselves, and who uses that representation as implicit justification for every request they make. She had said there was a problem with his seat. She had not specified what problem. She had said she needed him to stand up while the situation was verified. Marcus had asked for a more specific explanation of what the problem was and what exactly was being verified. The flight attendant had repeated the request without providing the explanation. There were other first-class passengers around them, seated in their seats, with no similar request being made to any of them. Marcus's camera had begun recording at that moment, with the phone positioned in a way that captured the flight attendant, the seat, and the surrounding passengers without it being immediately obvious what was being done. If this is your first time on this channel, welcome. What this story reveals about how certain assumptions operate even in spaces where money should be the only relevant criterion will surprise you, and the outcome has a specific number that the airline had clearly not calculated when everything began. Hit subscribe right now and tell me in the comments, have you ever been treated as though you did not belong in a space you had paid to be in? Tell me down below. Marcus did not stand up from the seat. He stayed where he was with the phone recording discreetly and did something the camera captured and that anyone watching the video would recognize as the movement of someone who knows exactly what they are doing. He reached into his jacket pocket, removed the boarding pass, and placed it on the tray in front of him with the seat number visible to the camera. That simple gesture, showing the boarding pass without being asked, communicated several things simultaneously. It communicated that he had the document proving he was in the correct seat. It communicated that he knew the document existed and was relevant. And it communicated, in a way the camera captured with enough clarity to be seen by millions of people in the weeks that followed, that the problem with that seat was not the seat. It was who was in it. Marcus had arrived at that airport that morning with the routine of someone who had made that same journey hundreds of times. He knew where long-term parking was, knew which check-in line moved faster in that specific terminal, knew that the coffee shop on the right side after security had a better espresso than anything served on board, and that it was worth the extra 8 minutes it took to buy and walk to the gate. He had done all of this with the quiet efficiency of someone who no longer needs to think about these steps, because he had executed them enough times for them to become automatic. He had arrived at the gate with coffee in hand, had waited for the priority boarding call, had boarded before most other passengers, had reached his seat, 3A, window, left side of the first-class cabin, and had settled in with that familiar feeling of someone who is exactly where they plan to be. The flight attendant who approached his seat during boarding was named according to the badge. Marcus's camera captured with enough resolution to read Jennifer. She had arrived at 3A with an expression that Marcus would later describe in the statement he gave his attorneys as the expression of someone who had already made a decision before opening their mouth. There was no hesitation in the approach. There was none of the body language of someone bringing information that may be uncomfortable, but that has a clear factual basis. There was the posture of someone who had decided what they needed to happen and was communicating that decision in a way that presumed it would be carried out. The first thing she said was that there was an inconsistency in the seating system, and that she needed Marcus to accompany her to the front of the cabin while the situation was resolved. Marcus had asked her to specify which inconsistency. Jennifer had said the system was showing a double allocation for that seat, and that it was standard procedure to move one of the passengers while the situation was verified. Marcus had then asked the most obvious question available at that moment: why he was being asked to move rather than the other passenger who was supposedly also allocated to the same seat. Jennifer had not answered that question directly. She had repeated that it was standard procedure and that she needed him to accompany her. Marcus had looked around the first-class cabin. There were 4 other passengers already seated, all white, none of them being approached. There were 2 seats still empty, including the seat beside his, 3B. And there was one very simple fact that made the double allocation story immediately questionable. If there was a double allocation at 3A, any airline's standard resolution would be to check the boarding passes of both passengers before asking either one to move. Jennifer had not asked for Marcus's boarding pass. She had asked him to stand up. It was at that moment that Marcus removed the boarding pass from his pocket and placed it on the tray. He pointed to the seat number printed on the card, 3A, and then pointed to the number printed on the seat back in front of him, also 3A, and said with a calm the camera captured as the calm of someone being deliberately clear because they want every word to be comprehensible to anyone who watches what is being recorded, that his boarding pass showed he was in the correct seat and that he was willing to wait in the seat while the supposed inconsistency was verified the way any genuine inconsistency would be verified, by consulting the system and the records, not by asking a passenger to stand up without first checking their documents. Jennifer listened to this with the expression she had brought from the beginning, and that had not changed throughout the interaction up to that point. Then she said something Marcus had not anticipated, and that the camera captured with enough clarity that there was no doubt about what had been said. She said there were other passengers waiting, and that his attitude was delaying the boarding process. The word attitude, said with that specific tone that carries a weight that goes beyond its literal meaning, that suggests the problem is not the situation, but the way the person is responding to the situation, that reframes the person exercising their rights as the obstacle rather than the person violating those rights. Marcus had heard variations of that word, said that way enough times throughout his life to immediately recognize what it was being used to do in that moment. He had not responded with anger. He had responded with a question, asking whether Jennifer could call the cabin supervisor because he would like a supervisor to be present while the situation was resolved. That request for supervision had produced in Jennifer's expression a change the camera captured and that anyone watching would describe as the moment it became clear that the situation was moving out of the control she had presumed to have over it. The cabin supervisor arrived 2 minutes later. His name was Robert. He had the kind of posture of someone with more years of service and more experience in the conflict situations with passengers than Jennifer, and he had arrived with the expression of someone who did not yet know what he was walking into, but knew he needed to assess before acting. Marcus explained the situation sequentially and factually, showed the boarding pass, pointed to the seat, and then did something Robert had not anticipated. He turned the phone and showed that a recording had been in progress since the beginning of the interaction, not as a threat, as information. Robert's expression at that moment, captured by the camera Marcus had just revealed was recording, was the second most analyzed moment of the entire video when it became public weeks later. Because it was the expression of someone simultaneously processing what had happened, what was recorded, and what that meant for everything that would happen from that point forward. Robert was silent for perhaps 5 seconds after Marcus revealed the recording. 5 seconds that the camera captured with the ambient sound of the plane in the background, the sound of passengers still boarding through economy class, bags being stowed in overhead compartments, the normalcy of a regular boarding serving as sonic contrast to that pause happening in the first-class cabin. When Robert spoke, the tone had shifted from what Marcus had described of Jennifer's arrival. There was in it a carefulness that was not necessarily empathy, but was the carefulness of someone who understands that every word spoken from that moment forward is being recorded and will need to be defensible. He asked for Marcus's boarding pass. Marcus handed it over. Robert examined it, verified the seat number, and then did something Jennifer had not done at any point in the prior interaction. He checked the system on the tablet he was carrying and confirmed out loud that seat 3A was correctly allocated to Marcus's name. That confirmation, spoken by Robert out loud and captured by the camera with enough clarity to be transcribed, was the logical end of the situation. The seat was correct. The passenger was in the right seat. There was no double allocation. The story that had been used to justify the request for Marcus to stand up had been verified and had turned out to be non-existent. In any reasonable sequence of events, that would have been the moment Robert apologized for the confusion, returned the boarding pass, and continued with the boarding process. But what happened next was not that, and what happened next was what transformed an incident that could have been closed at that moment into a process that would cost the airline a 7-figure amount and produce one of the most watched recordings of the year in that segment of discrimination cases. Jennifer had been standing beside Robert during the verification. When he confirmed that the seat was correctly allocated, she said, something the camera captured, and that Robert had clearly not anticipated she would say at that moment. She said that other passengers had reported feeling uncomfortable with Marcus's presence in the cabin and that the company's protocol allowed for the reallocation of passengers in situations where the comfort and safety of other passengers were a concern. That allegation, that other passengers had reported discomfort, appeared for the first time at that moment of the interaction, had not been mentioned during any of the prior approaches. And there was a very simple reason for that which anyone watching the video would immediately identify. It had been constructed in real time as a response to the fact that the double allocation story had collapsed. It was a second narrative being created at the moment the first one had stopped working. Marcus pointed that out explicitly, and the camera captured every word. He said that the allegation of other passengers' discomfort had not been mentioned at any prior point in the interaction, and asked which passengers specifically had reported that discomfort and when that report had been made. Jennifer did not provide any specific names. She said she could not disclose other passengers' information. Marcus then asked whether Robert could verify whether there was any record in the system of any passenger having made that request before or during boarding, before the initial approach. Robert went to check. Marcus stayed in the seat. The camera kept recording. There were other first-class passengers who could hear that conversation from their seats, and at least 2 of them had turned their heads in the direction of 3A with expressions the camera captured in the background. Expressions that were unambiguously the expressions of people who were hearing something that was surprising them. Robert returned 3 minutes later with an expression that had changed perceptibly from the one he had when he left to check. There was in him now something that was not exactly discomfort, but was adjacent to it. The expression of someone who has just found information that makes the situation they are in more complicated than they had imagined when they got involved in it. He said there was no record in the system of any passenger having reported discomfort before or during boarding. He said Marcus's seat was confirmed, and he said, with that verbal carefulness of someone trying to close a situation without explicitly admitting what the situation implied, that Marcus was free to remain in his seat and that he was sorry for the confusion. Jennifer was standing beside him when he said that. The camera captured her expression during those words. It was not the expression of someone who had just understood they had made a mistake. It was the expression of someone who had not yet arrived at that conclusion. What happened in the following 10 minutes was captured by Marcus's camera in fragments, because he had lowered the phone, after Robert's confirmation, but had left the recording active in his pocket, capturing audio of sufficient quality to be relevant. Jennifer had stepped away after Robert's words, but had returned to 3A 2 more times during the remainder of boarding, once under the pretext of checking whether Marcus needed anything, and once with no articulated pretext, simply pausing briefly beside the seat with the posture the camera had captured from the beginning. Each of those interactions had been brief and without additional incident, but the camera had recorded their frequency in a way that Marcus's attorneys would later describe as documentation of a pattern of behavior that went beyond the initial episode, and that was relevant to characterizing what had happened in that cabin as something systematic rather than an isolated moment of poor judgment. The plane landed at Marcus's destination 5 hours and 40 minutes after boarding. During that time, the first-class service had been conducted by Jennifer and a second flight attendant, and the difference between how Marcus had been served and how the other passengers in the same cabin had been served was documentable through the audio the pocket camera had captured intermittently during the flight. It was not a dramatic difference. There was no additional incident that compared to what had happened during boarding. It was a difference in details, in the frequency of check-ins, in the tone of interactions, in the speed with which requests were attended to. It was the kind of difference that each individual passenger experiences subjectively, and that normally leaves no verifiable record. But the camera had captured enough fragments of those details that, when analyzed together, they established a line of continuity between what had happened during boarding and what had continued, happening over the following 5 hours. Marcus had spent part of the flight with his phone on the tray in front of him, open on a document where he had begun recording every detail of the incident, with the precision of someone who knows that memory is fallible and that contemporaneous documentation carries different weight than subsequent reconstruction. He had noted the approximate times of each interaction with Jennifer during boarding, had described the content of each exchange, had noted the names visible on the badges, had documented the absence of any system record confirmed by Robert, and had recorded the 2 additional visits Jennifer had made to his seat after the situation had nominally been resolved. That document, created on board the plane while the details were still immediate, would become one of the most important corroborating pieces of the lawsuit that would develop in the weeks that followed. Because it had been created before any strategic consideration about the case could have influenced what was included or excluded. When the plane landed and passengers began disembarking, Marcus stayed in his seat until most of the other first-class passengers had left. Not out of hesitation, for a specific reason he had decided during the flight. He wanted to document the state of the seat and the surrounding space before leaving, including the boarding pass he had placed on the tray during boarding, and that had remained there visibly throughout the flight. The camera captured that final moment in the cabin, the empty seat beside him, the boarding pass with 3A printed on it, and the first-class cabin, with the specific quality of a space being left behind. It was an image without drama, but with a documentary completeness that Marcus's attorneys would value when the body of evidence was analyzed for the first time. Marcus contacted a law firm specializing in racial discrimination and consumer rights the morning after the flight. He had researched the night. Before, had identified a firm with a specific track record in cases against airlines, and had sent an email at 11 at night with a detailed description of the incident and a direct question about whether there was legal basis for a lawsuit. The response had arrived at 6 the following morning, which was itself an indicator of how the firm had assessed what it had received. The attorney who responded had said she needed to see the recording before making any formal assessment, but that the description Marcus had provided, if corroborated by the video, described a set of facts that fell into multiple categories of violation of federal anti-discrimination legislation applicable to air carriers. The recording was sent that morning. The formal assessment arrived the following day. The attorney had watched the video 3 times, had shared it with 2 colleagues at the firm who had watched it independently, and all had reached the same conclusion. The recording showed a sequence of events that supported with direct and verifiable evidence allegations of racial discrimination in a public transportation service, which was a specific category of legal protection with established jurisprudence and a history of cases that had resulted in significant settlements when the evidence was sufficiently clear. The evidence in this case was, in the firm's assessment, clearer than in most cases they had conducted. The camera had captured the initial approach, had captured the double allocation story being presented without basis, had captured the story of other passengers' discomfort being created in real time after the first had collapsed, and had captured Robert's confirmation that neither narrative had support in the system. It was a documented progression of two false allegations used sequentially to attempt to remove a black passenger from a first-class seat that had been legally purchased and paid for. The airline was formally notified of the intent to sue 15 days after the flight. The notification included a detailed description of the incident, the names of the employees involved as identified in the recording and flight records, and a specific reference to the existence of video material documenting the interaction. There was also a very clear instruction that any attempt to access, alter, or destroy internal records related to the flight, including seat allocation system logs, onboard communications records, and any documentation related to interactions with Marcus during that specific flight, would be treated as obstruction with all applicable legal consequences. The firm had learned in prior cases that airlines have automatic archiving systems that overwrite operational logs in relatively short windows, and that the explicit notification about evidence preservation needed to arrive before those automatic processes created a loss that would afterward be difficult to distinguish from deliberate destruction. The airline responded to the formal notification 12 days after receiving it through a letter signed by the legal department that followed the standard structure of institutional responses to litigation threats. Formal acknowledgement of receipt of the notification, declaration of commitment to internal investigation, and language about the company's values regarding equal treatment of all passengers, constructed in a way that sounded like accountability without admitting any specific fact. Marcus's attorney had seen variations of that letter enough times to know what it communicated beyond what was written. The company had assessed the situation enough to understand it needed time before deciding how to respond substantively, and was using the language of internal investigation as a mechanism to create that time without committing to any specific legal position. The lawsuit was filed in federal court 22 days after the notification, when it became clear that the internal investigation the company had promised had not produced any substantive communication, and that the time created by the initial response was being used to build a defense rather than resolve the situation. The filed document was 84 pages long and had been constructed with a specificity that reflected the quality of the available evidence. Each allegation was anchored in a verifiable moment of the recording with specific timestamps and transcriptions of the captured audio. The progression of the two false narratives, first the double allocation and then the discomfort of other passengers, was documented in a way that showed not only that the allegations were false, but that the second had appeared immediately after. The first had been disproved by the company's own supervisor, which established an intent to find any available justification to remove Marcus from the seat, regardless of the factual validity of that justification. The company had done, in the weeks between the notification and the filing of the lawsuit, something that Marcus's attorneys had anticipated but hoped not to have to confront. It had attempted to contact Robert, the cabin supervisor, through internal channels and had held at least one meeting with him that had not been spontaneously disclosed, but had been discovered during the discovery process when internal communications records were formally requested. That meeting had occurred 12 days after Marcus's notification, which was also the same day the company's formal response had been sent. The coincidence of dates had been noted by Marcus's attorneys and had become part of a line of questioning during depositions that produced responses from Robert that were, in the most charitable interpretation, carefully imprecise about the content of what had been discussed in that meeting. Jennifer had been removed from flight duties 2 weeks after the filing of the lawsuit, in a decision the company had described internally as an administrative measure during the investigation, but that had been communicated externally in a way sufficiently ambiguous not to confirm any acknowledgement of responsibility. That ambiguity had been deliberate and had been noted by both Marcus's attorneys and the journalists who had begun following the case after the existence of the video became public knowledge. The recording had reached the press not through any action by Marcus or his attorneys, but through a source close to the case who had shared the video with a reporter who covered cases of racial discrimination in public transportation services. When the video was published, the reaction had been immediate and had followed the pattern that videos of that kind produce when the evidence is sufficiently clear. broad outrage, extensive coverage, and pressure on the company that made each subsequent public statement more difficult to formulate than the previous one. The company had attempted, in the days following the publication of the video, to produce a narrative about the incident that acknowledged what was visible in the recording without admitting discrimination. It had spoken about a communication failure, about procedures that would be revised, about the company's commitment to diversity and inclusion. Each of those statements had been analyzed in parallel with the specific moments of the recording that contradicted the language used, and that analysis had circulated on the same platforms that had amplified the video, creating a layer of public fact-checking that made the company's communication strategy progressively less effective with each attempt. The public that had watched the video had seen Jennifer create a second narrative in real time after the first had collapsed. When the company created public narratives about communication failure, the memory of that specific moment made those narratives difficult to receive without skepticism. Depositions began 6 weeks after the filing of the lawsuit. Jennifer was deposed first, and what was recorded in that session was the kind of testimony that legal practitioners describe as involuntary documentation, because the answers she gave to questions about each specific moment of the recording were systematically inconsistent with what the camera showed in a way that could not be attributed to isolated memory lapses, but that configured a pattern of reconstruction of events that diverged from the recorded evidence at precisely the points most relevant to the lawsuit's central allegations. About the double allocation, she had said she had received the information from a colleague before boarding, but had been unable to identify which colleague or at what specific moment that communication had occurred. About the allegation of other passengers' discomfort, she had said it was her perception based on the body language of surrounding passengers, which was a completely different version from what she had said during the interaction, when she had stated that passengers had actively reported the discomfort. Each of those inconsistencies was documented by Marcus's recording on one side and by Jennifer's own deposition on the other, and the juxtaposition of the two sources was, in the assessment of the attorneys present, sufficiently clear to dispense with any additional argument about the credibility of the version Jennifer was attempting to construct. The agreement was announced on a Tuesday morning, 4 months and 18 days after that flight. The number that leaked before the official confirmation, and that was confirmed by sources close to the proceedings when the press began reporting, had 7 digits. It was not the highest amount ever paid by an airline in a racial discrimination case, but it was among the most significant of the last decade in that specific category. And what made it notable was not only the amount itself, but the context in which it had been reached. A process that had lasted less than 5 months from filing to agreement, at a speed that indicated the company had assessed the risk of going to trial with that recording as central evidence and had reached a conclusion that made any settlement amount preferable to the potential cost of a jury watching the complete video in a courtroom. Marcus's attorney had negotiated the agreement with a clarity about what was and was not negotiable that she would later describe in an interview with a specialized legal publication as the result of having evidence solid enough not to need to make concessions that would weaken what the case represented beyond the individual client's interest. The financial amount had been discussed with Marcus from the beginning as secondary to the institutional conditions, not because the money did not matter, but because Marcus had been explicit from the first consultation that the outcome he wanted from the process was an outcome that changed something beyond his bank account. He had told his attorney in one of the first meetings that there were people who went through the same experience in that same type of seat on that same type of plane without a camera and without the resources to hire the right firm, and that the process needed to produce something that existed beyond that specific flight. The institutional conditions of the agreement reflected that determination with a specificity that Marcus's attorney had insisted be verifiable and not merely declarative. Jennifer was dismissed as a condition of the agreement, not transferred, not suspended for a fixed period, dismissed, with a notation in her employment record that prevented rehire in any passenger-facing role at airlines that shared the industry's human resources database. Robert received a 90-day suspension without pay and was required to complete a training program on racial bias and on the obligation to intervene when witnessing discriminatory conduct, with documented verification of completion. The company was required to completely revise its seat reallocation protocols, creating a system that required verifiable documentation of any systemic problem before any reallocation request could be made to a passenger, and that automatically recorded each reallocation request with the name of the employee who had made it and the time at which it had been made. That last condition, the automatic recording of reallocation. Requests was the one that passenger rights specialists who followed the agreement described as potentially most impactful in the long term, because it created an accountability infrastructure that did not depend on any specific passenger having a camera or having resources to sue the company. Each reallocation request would be recorded with enough information for patterns of discriminatory behavior to be identifiable through data analysis over time, even when no individual incident had sufficient evidence to sustain an isolated lawsuit. It was a systemic change of a nature that individual lawsuits rarely produce, and had been negotiated with the precision of someone who had understood from the beginning that the camera had given Marcus an opportunity that most people do not have, and that using that opportunity to create something larger than an individual settlement was the only proportional response to the responsibility that opportunity created. Marcus issued a public statement on the day the agreement was confirmed. It was short, 5 paragraphs, and had been written by him without attorney involvement in the drafting, although it had been reviewed by them before publication. He did not describe the settlement amount. He did not describe Jennifer or Robert by name. He used no language that suggested personal satisfaction with the outcome beyond the acknowledgement that it was a fair result. What he described, with a clarity that recalled the calm with which he had shown the boarding pass in that cabin months earlier, was what he had learned throughout that process about the difference between cases that produce change and cases that produce only compensation. He had said that difference was not in the severity of the discrimination suffered, because there were people who experienced equally severe or more severe discrimination without a camera and without an attorney. It was in the resources available to transform the experience into evidence, and the evidence into process, and the process into conditions that existed after the process ended. And he had said that as long as that difference existed, every person with access to those resources had a responsibility about how they used them that went beyond their interest in their own case. Seat 3A on that specific plane had been occupied by other passengers in the months between Marcus's flight and the agreement. The company had continued operating that route, that plane had continued flying, and the life of that first-class cabin had continued with the normalcy of spaces where significant incidents happen and leave marks that are not visible on the surface. But there was now, recorded in the company's system by legal obligation resulting from the agreement, a protocol that had not existed before. Marcus sat in that seat and Jennifer appeared beside him with that decision already made. Every reallocation request made from that agreement forward was being recorded with name, time, and documented justification. It was a small change relative to the size of the problem it represented, but it was a real, verifiable change that existed independently of any public attention or media pressure, and that had been created because a man had purchased a first-class seat, had paid what had been asked, and had arrived at the airport with a phone in his pocket and the reflex to press record when something that should not be happening begins to happen.
Drop the weapon. Put your hands where I can see them.
What weapon? This is my walking stick. I'm blind.
Don't play games with me. I know a club when I see one.
Sir, I have a white cane. I'm visually impaired.
Right, and I'm supposed to believe that?
He was walking along the sidewalk with the white cane in his hand, making the characteristic lateral movement that anyone who knows someone with a visual impairment immediately recognizes, that low and rhythmic arc that serves to map the space ahead and navigate the world without seeing it. It was a November afternoon. The sky was blue and clear over that busy commercial street, and there were people around coming and going in their own directions without anything in that scene suggesting any kind of problem. The man with the white cane was doing exactly what any person does on a public sidewalk on an ordinary afternoon. He was moving from one point to another with the assistance of the only instrument that made that movement possible for him. And then a police officer appeared in front of him, and the body camera that officer carried on his chest began recording something that, when it reached the right hands, would be impossible to defend. The body camera recorded everything from 3:27 in the afternoon on November 6th, 2024. It recorded the sidewalk, recorded the commercial establishments in the background, recorded the cars parked on the street, and recorded, with a clarity that left no room for any alternative interpretation, the white cane in the hand of the man being approached. That white cane was visible from the very first second of the recording. It did not appear later. It was not taken from somewhere during the interaction. It was there, in the camera's field of view, from the moment the officer got close enough that anyone with normal vision could identify it without any difficulty. And yet, what followed in the minutes after that first second was something that disability rights organizations, civil attorneys, and millions of people who watched the video in the weeks that followed described with the same words: incomprehensible. The man with the white cane was named James. He was 42 years old, had lost his vision gradually over a decade as the result of a degenerative medical condition, and had developed over that process the functional independence that visually impaired people build, with a combination of specific training, assistive technology, and the practical acceptance that the world was built for people who can see, and that navigating that world requires constant adaptation. He knew that street. He had walked that stretch dozens of times, knew how many steps there were between the bus stop and the entrance of the store he was going to visit, knew how the sidewalk changed texture at a certain corner, and carried the mental map of that neighborhood with the precision of someone who depends on spatial memory in a way that sighted people rarely need to develop. The officer who approached James that afternoon had been dispatched, according to the official account, that would be questioned in every detail in the weeks that followed, following a call reporting a man with suspicious behavior on that sidewalk. The description that had motivated the call, and that the officer had received over the radio before arriving at the scene, was vague enough to apply to any person within a radius of several blocks. But there was one element in the scene that made the suggestion of suspicious behavior not just unlikely, but actively absurd to anyone who arrived on that sidewalk with open eyes and no previously formed assumptions: the white cane. There was nothing ambiguous about that object. There was no second interpretation available. It was a white cane in the hands of a man in dark glasses on a public sidewalk, and it communicated with the precision of a universally recognized symbol that the person carrying it could not see. If this is your first time on this channel, welcome. This story becomes progressively harder to believe as the details unfold, and you are going to want to follow it to the end, because the outcome says something important about what happens when evidence is clear enough to not be ignored. Hit subscribe right now and tell me in the comments, can you imagine being approached by a police officer for walking down the street with your own cane? Tell me down below. The video the body camera produced that November afternoon would become, in the weeks that followed, one of the most watched and most discussed recordings in the debate about abuse of authority and racial discrimination in the United States during that period. Not because it was the most violent case that had appeared in that debate, but because it contained a combination of elements that made it impossible to construct any defense that would not immediately collapse upon contact with the images: a black man, a white cane visible from the first second, and a police officer who had decided that none of those elements altered the course of action he had predetermined before arriving on the sidewalk. That combination, recorded in high definition with the date and time in the upper right corner of the screen, was what cost the officer everything he had built over years of service. James had left home that afternoon with a simple and specific goal. There was a musical instrument store 6 blocks from the apartment where he lived, and he had called that morning to confirm that the item he had ordered had arrived. The employee who answered had confirmed it, had given an estimated time when the store would be less busy, and James had planned his outing with the kind of advanced preparation that visually impaired people develop as a habit, because each independent trip requires a level of planning that goes beyond what most people need to consider. He knew the route, had checked on his phone's accessibility app whether there were any interruptions or construction along the way, had left with enough time not to need to quicken his pace, and had arrived on that commercial street without incident until the moment the officer appeared in front of him. The officer's name was Officer Brett Larson. He had 9 years of service in the department, had worked that commercial zone for 3 of the last 4 years, and knew that street with the familiarity of someone who had patrolled it in different shifts and weather conditions over hundreds of working days. That detail, that Larson knew that street, was relevant because it made even less sustainable any argument that he was unfamiliar with the kind of movement visually impaired people make on a public sidewalk, or that there was some characteristic of James's navigation with the cane that could legitimately seem suspicious to someone with patrol experience in that specific environment. There were visually impaired people who regularly frequented that commercial street. The white cane was not an unusual object in that context. It was simply a white cane. The call that had dispatched Larson had been made by a shopkeeper, whose establishment was half a block from where James was when the officer arrived. The shopkeeper had described a black man walking erratically on the sidewalk and potentially disturbing customers. That description would later be contested by at least 4 people who were on the street at that moment, and who would give statements confirming that James had walked along the sidewalk without disturbing anyone, without approaching any establishment beyond the one he was going to visit, and without any behavior that could reasonably be described as erratic by any objective standard. Navigation with a white cane has a specific appearance that can look different from the walking pattern of a sighted person, but that any basic training in interacting with people with disabilities teaches you to immediately recognize. What the shopkeeper had described as erratic was simply the way James walked. Larson arrived at the scene and saw James walking on the sidewalk with the cane. The body camera captured that moment with a clarity that would make that first second of the recording the most analyzed of the entire video in the weeks that followed, because it was the moment that it established what Larson had seen before, saying or doing anything. The cane was visible. The characteristic movement with it was visible. The dark glasses James was wearing, which in combination with the white cane, composed an image whose interpretation should not have required any deductive effort, were visible. Larson stopped James and began asking questions in the tone the camera captured as the tone of someone who arrived with a conclusion and is collecting information to support it, not to evaluate it. That distinction between investigating and confirming what has already been decided was audible in every question Larson asked in those first minutes. James responded with the calm of someone who has been caught off guard, but who has enough experience with the world to quickly understand the nature of what is happening. He identified himself, explained where he was going, mentioned the musical instrument store and the item he had ordered. He held the white cane in a way the camera showed clearly, not because he was trying to use it as proof of something, but simply because it was what he was carrying and what he needed to continue walking when that conversation ended. Larson looked at the cane. The camera recorded that look. And then Larson did something that none of the people who watched the video afterward could explain with any logic that held up. He asked James to put the cane on the ground. That request that a blind man place on the ground, the only instrument that allowed him to navigate independently in that space, was the moment the recording became something that transcended the specific case of James and Larson and became a document of something broader and more disturbing. It was not merely a misjudgment. It was not merely a poorly conducted approach. It was a request that only made sense if the person who made it had decided, at some level, the camera could not record, but that the actions made inferable, that no visible element in that scene altered. The narrative he had brought with him to that sidewalk. The white cane was there. The request was made anyway. And James, who could not see Larson's expression, but who could hear every word and every tone with the auditory acuity developed through years of sensory compensation, understood in that moment that the conversation he was having had nothing to do with anything he had done. James did not put the cane on the ground. He explained with a patience the camera captured, and that anyone watching the video would recognize as the exhausting kind of patience that develops when you spend years having to explain the existence of your own disability to people who should know but do not. That the cane was a mobility instrument, and that putting it on the ground was not something he could do without compromising his ability to remain oriented in that space. He said this directly and without aggression, the way someone explains something they consider obvious but is willing to articulate once because the situation demands it. Larson heard the explanation and made the request again. The camera recorded that sequence, James's explanation and Larson's repetition of the request, with a clarity that made it impossible to argue afterward that there had been some communication failure or misunderstanding about what was being said by each party. What Larson did next was the moment that would become the center of all subsequent coverage of the case, and that would be reproduced billions of times on digital platforms in the weeks that followed. He reached for James's cane, did not ask again, did not wait. He extended his hand and attempted to remove the cane from James's hands, who instinctively held it more firmly, because removing the cane from a blind person's hands in a public space removes their capacity for independent orientation. And anyone who spends a day training mobility with visual impairment understands this in a way that someone who has never experienced it cannot completely imagine. James held onto the cane. Larson interpreted that as resistance, and the camera captured every second of that sequence with a fidelity that left no room for any alternative narrative about what had happened. The situation escalated in a period of time. The camera's timestamp would record as less than 90 seconds between the first request to put the cane on the ground and the moment Larson called for backup over the radio. The backup call was described over the radio as a resistant individual who was refusing to comply with orders and who might represent a risk to public safety. That description, which reached the ears of every agent who responded to the call before they arrived at the scene, was the same dynamic that had appeared in other cases examined on this channel. The narrative transmitted over the radio defined how every person who arrived would process what they found, regardless of what was actually happening at the location. What was actually happening was a blind man holding his own cane on a public sidewalk. What would reach the ears of the backup agents was a description of danger. 3 people who were on the sidewalk at that moment stopped when they saw what was happening. 2 of them took out their phones and began recording. That decision, made independently by 2 strangers who did not know each other, but who simultaneously recognized that they were witnessing something that needed to be documented, produced 2 additional angles of the same scene that would complement Larson's body camera in ways his legal team had certainly not anticipated when the situation began. One of the recordings captured the scene from a lateral angle that clearly showed the white cane standing out against the gray sidewalk, making it even more impossible to argue that the object was not immediately identifiable. The other recorded from a slightly elevated angle that showed James's expression throughout the interaction, an expression that anyone watching would describe as the expression of someone processing the reality of a situation that should not be happening but is. Backup arrived in 4 minutes. 2 additional agents who had received Larson's radio description and who arrived with the posture of people informed that there was active resistance. When they saw the scene, when their own eyes did the work that Larson's body camera had already done 4 minutes earlier, something should have changed. The white cane was visible to them in the same way it had been visible to Larson. James's dark glasses were visible. The nature of the situation was visible. One of the backup agents, whose name was not released during the initial investigation, but who was identified later, paused when he arrived at the scene in a hesitation the camera on his chest recorded as perhaps 3 seconds long. 3 seconds during which he assessed what he was seeing with his own eyes before the group dynamic and the narrative he had received over the radio took over. He did not intervene. He followed the implicit protocol of supporting the colleague who had initiated the approach. That decision not to intervene, when there was clear reason to question what was happening, would become a separate element of the subsequent investigation. James was detained on that sidewalk. He was guided by the arms by 2 agents to the patrol car with the white cane being carried separately by Larson as though it were a seized object, which produced in the body camera an image that would be described by disability rights specialists as one of the most disturbing representations of institutional abuse they had seen documented on video, because the separation between James and his cane was not merely symbolic, it was functional. It was the removal of a blind person's capacity for independent orientation, executed by a state agent in a public space, recorded on body camera, and impossible to frame as anything other than what it was. James was detained for 48 minutes. That number, which the body camera and the department's dispatch records documented with precision, would become one of the most cited details when the case gained public attention, because it represented 48 minutes during which a blind man was separated from the cane that was his primary mobility instrument in a patrol car, with no charge that held up and no explanation that made sense to anyone who had watched the first seconds of the recording. During that time, the musical instrument store where James was supposed to have arrived in the early afternoon was open. The employee who had confirmed the order that morning was waiting, and the item James had ordered was on the counter. None of those circumstances had changed. What had changed was that James was in a patrol car instead of covering the last blocks of the route he had planned so carefully that morning. The release process began when a supervisor arrived at the scene and assessed the situation with her own eyes. The supervisor was Sergeant Patricia Howell, with 18 years of service, and she had arrived not in response to Larson's backup call, but because her patrol route that afternoon passed through that commercial street, and she had seen the patrol car stopped with lights on, and 2 agents on the sidewalk. When Howell approached and was briefed on the situation by Larson, she immediately requested access to the body camera to review what had been recorded. That review lasted less than 3 minutes. When it ended, Howell instructed Larson to release James immediately, return the cane, and document the incident completely. Larson's expression during that instruction was captured on Howell's body camera, which she had activated upon arriving at the scene per standard protocol, and it was the expression of someone who had not yet fully processed why the situation was being ended the way it was being ended. James was released with the cane returned, and with no formal explanation of what had justified the detention in the first place. Howell approached him after Larson had stepped away and attempted to offer an explanation the camera captured as a genuine attempt to do something that protocol had not prepared her to do in that specific situation. She said there had been a misunderstanding, that she was sorry for the inconvenience, and that James was free to continue on his way. James listened to that in silence for a moment. Then he asked a question that Howell had not anticipated, and that the camera captured with audio clear enough to be transcribed afterward. He asked for the name and identification number of every agent who had participated in the detention. It was not an aggressive question. It was a question asked with the precise calm of someone who had decided, during those 48 minutes in the patrol car, what they were going to do when they got out of it. Howell provided the information. James recorded it on his phone using the voice system he used to type, a system the camera captured functioning while James held the phone in a specific way. Another visual detail that anyone watching the video would recognize as yet another confirmation that they were looking at a visually impaired person using assistive technology. That moment, James recording the agents' names and numbers through the voice system while Howell watched, had an almost documentary quality that several legal commentators would note when the video became public. It was the moment the situation turned, when the person who had been treated as a suspect was clearly taking the steps that would transform that afternoon into something with permanent consequences for the people involved. The two recordings made by bystanders on the sidewalk had continued during part of the detention and continued during the release. One of them captured the moment the cane was returned to James, and that specific moment would become perhaps the most shared image of the entire case in the weeks that followed, because it contained a visual economy that communicated everything that needed to be communicated without any additional narration. The cane returning to James's hands, his posture shifting slightly as his fingers wrapped around the familiar handle. The reorientation movement he made immediately afterward, the low rhythmic arc beginning again, mapping the surrounding space after 48 minutes without that information. Anyone watching that moment understood, viscerally and immediately, what had been removed and what had been returned, and understood also, with the same immediacy, what could never be completely returned. The musical instrument store was closed when James arrived there 22 minutes after being released. He had called while walking the final blocks, but the employee who had answered that morning had finished his shift, and whoever was now answering had not been informed of the order. James stood on the sidewalk in front of the store for a few minutes, cane in hand, processing the end of an afternoon that had begun with a planned route and an item waiting on the counter. He had not gotten what he had left home to find. He had lost 48 minutes that could not be recovered, and he had in hand the names and identification numbers of the agents who had made that afternoon what it had been. The store would be open the next day. The process he was about to begin would take longer than that. But James had learned over a decade of adapting to a progressive disability that the time necessary to do the right things rarely corresponds to the time you had planned to use. The video reached social media 48 hours after the incident. One of the two bystanders who had recorded the scene on the sidewalk had hesitated before publishing, not for lack of conviction about what he had documented, but because he had spent those 48 hours trying to decide whether there was any way for that recording to exist in the public space without the unpredictable consequences that videos of that kind sometimes produce. He had watched what he had recorded dozens of times, had shown it to people close to him, had received back the same assessment he had arrived at alone, that what was in that video needed to be seen. He published on a Saturday afternoon with a simple caption that described what had happened without editorializing, without inflaming, just the facts in sequence. The video was 93 seconds long. In 12 hours, it had 2 million views. The speed with which that video spread said something about what it contained that resonated. Immediately and across very different audiences. It was not only the outrage at James's treatment, although that outrage was real and intense. It was the white cane. It was the specificity of that symbol and the absolute clarity of what it communicated, and the contrast between that clarity and what the officer had done anyway. People who had no direct experience with visual impairment understood what a white cane meant. People who had direct experience, either as visually impaired people or as family members, saw in the video something that went beyond that specific incident and that touched on a kind of vulnerability that existed at the intersection of disability and race in a way that had rarely been documented with such clarity. Disability rights organizations were the first to issue formal statements, and they came with a technical specificity that complemented the emotional reaction of the general audience. Those organizations described what Larson had done in precise legal terms, citing specific violations of the Americans with Disabilities Act, which prohibits discrimination based on disability by public agents and establishes very clear obligations about how government institutions must interact with people with disabilities in public spaces. They pointed out that removing or attempting to remove a mobility instrument from a person with a disability without legal justification is a documentable violation of that legislation that exists independently of any other allegation of abuse of authority or racial discrimination. James's case was not only a case of discriminatory policing, it was also a case of violation of federally protected rights of a specific category that created an additional legal pathway with its own liability structure. Civil rights organizations joined the statements in the following 24 hours, and the combination of the two fronts created pressure on the department that was qualitatively different from the pressure that individual cases of police abuse normally generate. Because there were two different sets of federal legislation being invoked simultaneously, and the department needed to respond to both in a way that did not create contradiction between the responses. Any statement that tried to minimize the racial issue compromised the response to the disability issue, and vice versa. And any attempt to argue that Larson had acted in good faith or within the limits of operational discretion collided with the fact that the body camera showed the white cane from the first second, which made any argument about insufficient information impossible to sustain. The department issued a statement 48 hours after the video had gone viral. It was the kind of statement departments issue when they need to say something, but are not ready to say what they need to say, full of language about institutional values and commitment to fair and transparent investigation, with no specific acknowledgement of what the recording showed and no mention of the white cane that was at the center of everything. That statement was received with a reaction the department had probably not anticipated in its extent. It was read as evidence that the institution had not yet made the most basic assessment of what was recorded on its own agent's body camera, because anyone who had made that assessment could not produce that statement without mentioning the cane. The statement generated more negative reaction than silence would have generated, which was a clear indicator that the communication strategy had failed before it was even fully executed. James had retained a law firm specializing in civil rights and disability rights 3 days after the incident, before the video went viral, but after doing enough research to identify who had experience in both fields simultaneously. When the video became public and the pressure on the department began accumulating in a way that anyone following the case could measure, James's attorneys had contacted the department through the appropriate formal channels, informing them that a lawsuit was being prepared, and that any destruction, editing, or loss of evidence material, including all body camera recordings of the incident, would be treated as obstruction with all applicable legal consequences. That notification had reached the department before the public statement, which meant that when the statement was issued, the department already knew a lawsuit was coming, and that the recordings were being preserved by legal obligation. The vague statement they had issued in that context communicated even more clearly than it would have, under normal circumstances, that the institution had not yet decided how to deal with what it knew was recorded. Larson was placed on paid administrative leave the week after the video went viral, which was technically an administrative measure and not a punishment, but which the department had learned from the public reaction to its previous statements needed to be announced with language that acknowledged the gravity of what had happened, rather than framing it as routine procedure. The announcement of the suspension explicitly mentioned the body camera and what it had documented, which was a significant change from the initial statement that had avoided mentioning the white cane. That shift in language between the first statement and the suspension announcement was, for anyone who had followed the case from the beginning, a clear indicator that the department had finally watched the video through the eyes of someone who needed to respond publicly for what was in it, and had understood that the distance between the vague language of the first statement and the reality of the recording was unsustainable. The internal investigation was conducted over 6 weeks by a group that included, at the insistence of James's firm, as a condition for not accelerating the federal lawsuit immediately, an independent external reviewer with no ties to the department. That condition had been negotiated in the first days after Larson's suspension, when the department had made contact with James's attorneys signaling interest in resolution before formal proceedings. James's attorneys had agreed to keep the lawsuit in preparation rather than filing it immediately, but only under specific conditions that included the external reviewer, complete access to all recordings, including the backup agent's cameras, and access to Larson's complete complaint history over the previous 9 years. The department had agreed to all 3 conditions, which was itself an indicator of the internal assessment they had made about the strength of their position. Larson's complaint history revealed during the investigation had 4 entries prior to the incident with James. 2 had been filed after summary investigation, with no substantive details in the record. 1 had resulted in mandatory additional training that the records showed had been completed on paper, but with no verification that it had produced any documentable behavioral change. The 4th, which had occurred 18 months before the incident with James, involved an approach to a person with a hearing impairment that had been described by the complainant as disrespectful, and based on incorrect assumptions about the person's behavior, and had been filed with a note that the agent had received verbal guidance. That 4th complaint was the most relevant to James's lawsuit because it established that the department had previously been informed that Larson had a specific pattern of difficulty in interactions with people with disabilities and had responded with verbal guidance rather than substantive intervention. What had happened with James was, in his attorney's reading, the direct and foreseeable consequence of that institutional choice. The lawsuit was filed in federal court 8 weeks after the incident, naming Larson individually, the backup agent who had hesitated and not intervened, and the department as an institution. The central allegations covered violation of the Americans with Disabilities Act, civil rights violations with documentable racial motivation, and institutional supervisory negligence established by the complaint history that had been systematically ignored. The amount sought was not disclosed at the time of filing by strategic choice of James's attorneys, who had learned in prior cases that announcing specific amounts before the process develops frequently frames the public narrative in a way that benefits the opposing party more than the client. What was disclosed were the non-financial conditions that James had determined were non-negotiable from the first day, Larson's dismissal without possibility of rehire in any law enforcement capacity, complete revision of protocols for interacting with people with disabilities throughout the department, and verifiable mandatory training that could not be completed on paper alone. Larson was dismissed 4 months after the incident, after the internal investigation concluded that he had violated multiple departmental protocols and that the complaint history made it impossible to treat the incident as an isolated deviation. The police union filed an appeal that was denied on second review after the external reviewer confirmed the internal investigation's findings and added his own analysis that the white cane had been visible from the first second of the body camera and that no standard training in any department in the country could be interpreted as authorizing the approach that had been made. That specific language from the external reviewer, that no standard training authorized what had been done, closed the path to any operational discretion argument the union might have attempted to construct in a higher instance. James received the item he had ordered at the musical instrument store 3 days after being released on that sidewalk. During a visit the store had arranged outside normal business hours after the employee who had answered the call that morning learned what had happened. That visit was not on any recording and was not part of any legal record. It was simply a man walking into a store with his cane and leaving with what he had gone to find. The agreement that closed the federal lawsuit was signed 6 months after the incident. The financial amount remained confidential. The institutional conditions were made public at James's insistence, who had argued that the only outcome that justified the time and energy invested was an outcome that existed as a verifiable record beyond that specific case. Larson had lost his career, the department had changed its protocols, and James had returned to that commercial street some weeks after the agreement was signed, had covered the same route he had planned on that November morning, had entered the musical instrument store for the second time, and had left with his cane in hand navigating the sidewalk with the same low rhythmic arc that anyone who saw him would immediately recognize for what it was. The same movement that had been visible on the body camera from the very first second. The movement that should never have been enough for anything other than letting him pass.
Hold on. Did you just take that out of my cart?
The shelf was empty. I need this more than you do.
That's not how this works. Put it back.
I'm not putting it back. First come, first serve, right? You hadn't even paid for it yet.
Wow, you can't just steal from people because you feel like you need it more.
Watch me.
She had just gotten off work. Her jacket was still on, her car keys still in her pocket, and the shopping list she had written on her phone during lunch was open on the screen while she pushed the cart through the supermarket aisles with that specific efficiency of a mother who knows exactly what she needs, knows where it is, and has a limited window of time before she needs to be home. It was an ordinary Tuesday, the kind of Tuesday that should produce no memory worth telling, no moment that stands out from the other days of the week. And then she turned into the cereal aisle, stopped the cart, and when she looked back at it after reaching for something on the shelf, there was a blonde woman on the other side of the aisle holding a box that had come from her cart, with the naturalness of someone picking up something that belongs to them. The supermarket security camera was recording. It always records. That is what it exists for, capturing in a continuous loop every aisle, every interaction, every ordinary and extraordinary moment that happens between the shelves of a commercial establishment open to the public. On that specific afternoon, in the cereal aisle, it captured something that the employees who reviewed the footage later described as one of the most disconcerting interactions they had seen in years of working at that supermarket. Not because there was violence, not because there were shouts or physical confrontation, but because what was happening in those images was so clearly wrong and so clearly recorded that watching it produced in the viewer the kind of discomfort that comes from seeing someone being treated unfairly without anything in the surrounding environment seeming to notice. The woman with the cart was named Danielle. She was 34 years old, had spent the entire day working as a pediatric speech therapist at a health center that served children with communication difficulties, and was at that specific supermarket because it was on the way between work and home, and because her son, who was 6 years old, had asked that morning for the yellow box cereal he liked that had run out in the pantry. That cereal was now in the hands of the other woman. The blonde woman in the beige sweater, who had crossed the aisle, reached into Danielle's cart, removed the box, and was now holding it with an expression the camera captured as the expression of someone who does not understand why they are being questioned about something they consider completely natural. What had motivated that gesture was something the blonde woman, whose name the subsequent investigation would reveal to be Christina, would try to explain in different ways at different moments in the weeks that followed, and each explanation would be less convincing than the one before it, because none of them could answer the simplest question the video posed. Why did you take something from another person's cart? Christina was, according to her own social media, profiles that would become public knowledge after the case went viral, a lifestyle consultant, the kind of occupation that exists in the space between digital influencer and wellness coach. And that depends on a personal brand built around images of an organized, healthy, and aspirational life. What she had done in that cereal aisle was not consistent with any of those images, and the camera had captured every second of the inconsistency. Before we continue, if this is your first time on this channel, welcome. This story has an ending that Christina certainly had not calculated when she walked into that supermarket that afternoon, and you are going to want to follow every section to the end. Hit subscribe right now and tell me in the comments, have you ever seen someone treated this way in a public place and not known what to do? Tell me down below. Danielle looked at Christina with that expression the camera captured in detail, and that anyone who has ever been on the wrong side of an unfair situation immediately recognizes. It was not anger. It was the kind of calm astonishment that precedes anger when you are still in the process of confirming that what you are seeing is really what it appears to be. She pointed to the box in Christina's hands. Christina looked at the box, looked at the cart, looked at Danielle, and said something the camera recorded, but that the security system's audio did not capture clearly enough to be transcribed. What the camera captured with sufficient clarity was what happened next, and what happened next was the beginning of something that neither Danielle nor Christina would finish that week the same way they had started it. Danielle had arrived at that supermarket at 5:34 in the afternoon that day, tired in the specific way that a full day working with young children produces, which is different from physical fatigue and different from intellectual fatigue, and has a quality of its own that only someone who has spent years in a pediatric environment can describe precisely. She had seen 11 children that day, had conducted 3 language development assessment sessions, had had 2 meetings with parents and 1 with the center's multidisciplinary team, and had left work with that familiar feeling of having given the maximum available in those hours, and that what remained now was the time that belonged to her and her son. That time began with the shopping list and ended with the dinner she had already decided to make while driving to the supermarket. The cereal aisle was third on the list. She had picked up items from the first 2 aisles without incident, had waved to an employee she knew from shopping, there every week, and had entered the cereal aisle with the cart already partially full, and her attention divided between the shelf in front of her and her phone, where there was a message from her son asking what time she would be home. She had paused the cart, had replied to the message, had looked up to locate the yellow box cereal on the shelf, and had turned to reach for it. That turning motion lasted perhaps 15 seconds. When she brought her attention back to the cart, Christina was already there. Christina had entered the aisle from the opposite end. The security camera showed her arriving with a shopping basket on her arm, no cart, and moving along the shelves with the posture of someone looking for something specific. When she passed Danielle's cart, which was stopped in the middle of the aisle, while Danielle reached for the shelf, the camera showed something that was simultaneously simple and absolutely disconcerting. Christina stopped, looked at the cart, looked at the surrounding shelves, and then extended her hand and removed the cereal box that was in Danielle's cart, with a movement so casual and so devoid of hesitation that it appeared not to have crossed her mind for a single second that this was someone else's cart, and that what she was doing was removing an item that did not belong to her. Danielle saw it happen at the moment she was turning with the cereal from the shelf in her hand. She stopped for a second, processing what she had just seen, and then did the most reasonable thing any person would do in that situation. She asked, directly but without raising her voice, whether Christina had just removed that item from her cart. The question was recorded in the camera's audio clearly enough to be understood, and Christina's reaction to that question was what the camera captured and what anyone who watched the video described as the moment it became clear that this situation was not an innocent confusion that would be resolved in 10 seconds, with an apology and the return of the box. Christina did not return the box. She looked at Danielle with that expression the camera had captured, the expression of someone who does not understand why they are being questioned, and began to speak. The security system's audio captured enough fragments of that conversation for the attorneys who worked on the case afterward to reconstruct the substance of what had been said, even without a complete transcript. What Christina had communicated, in words that varied throughout that conversation, but that converged on a consistent central point, was that she had taken the box because she wanted that specific cereal, and there had been only one on the shelf, and that one was in Danielle's cart. She had said this not as someone who had just realized they did something wrong and is trying to explain a lapse in judgment. She had said it as someone who considers the logic of what they did sufficiently reasonable to require no more explanation than that logic, that Christina had taken the cereal from Danielle's cart simply because she wanted it, and because there was only one available, was so devoid of any consideration for Danielle's perspective as a person with equal rights over the products in that supermarket, that Danielle stood looking at her for a moment without immediately knowing how to respond. Not because she did not know what to say, but because the obvious response was so obvious that having to say it out loud in a conversation with an adult generated a specific kind of fatigue that goes beyond simple disagreement. She knew that fatigue. It was the fatigue of having to explain that you have the same right to be in a place that everyone around you assumes is guaranteed for themselves. And recognizing that fatigue in that supermarket aisle on a Tuesday afternoon, after a full day of work, was the moment Danielle decided she was not simply going to let it go. The conversation between the 2 women in that aisle lasted just over 3 minutes, according to the security camera's timestamp. 3 minutes that the recording captured at a sufficiently clear angle to show the body language of both, the position of the cereal box that remained in Christina's hands throughout the entire interaction, and the exact moment a supermarket employee entered the aisle, drawn by the elevated tone of the conversation. That employee, a young woman in a green uniform, who the camera showed arriving from the back of the aisle with the expression of someone not yet sure what they are walking into, would become one of the most important witnesses to everything that developed from that point forward, not because she had seen the beginning, but because she had arrived early enough to see enough. Christina had constructed during those 3 minutes a narrative that changed shape each time Danielle presented a direct counter-argument. First, there had been the logic of scarcity. There was only one box available, and she needed that specific cereal for a recipe she was making that week. When Danielle pointed out that the fact that there was only one box was precisely the reason she had placed that box in her own cart before Christina arrived in the aisle, the narrative shifted. Christina began suggesting that perhaps Danielle did not really need that specific cereal, that there were other options on the surrounding shelves that would be equally suitable, and that it would be much simpler if Danielle simply chose an alternative. That suggestion, that Danielle should surrender the item from her cart and choose an alternative as though Christina's convenience were a legitimate consideration in that equation, was the moment the employee who had entered the aisle understood that what she was witnessing was not a cart mix-up resolvable with friendly mediation. Danielle asked for the box to be returned directly and without detours. Christina did not return it. Instead, she did something the camera captured, and that would become one of the most discussed elements when the video circulated publicly. She turned slightly and placed the box in her own shopping basket with a movement that communicated closure, as though the matter were resolved by the simple action of putting the item away. It was the kind of gesture that only makes sense when the person making it assumes the other person will accept the conclusion implicit in it. Danielle did not accept it. She extended her hand toward Christina's basket with the clear intention of removing the box that was hers, and Christina stepped back, which was the moment the employee decided to intervene, and asked both of them to accompany her to customer service. What happened on the way to customer service was captured by 2 more security cameras positioned in the aisles through which the 3 women passed, and that additional material completed the timeline in a way that made it impossible to argue there was any ambiguity about what had occurred in the cereal aisle. Christina continued with the basket. Danielle's cereal box was still inside it, and Danielle walked beside the employee with that specific posture of someone containing a reaction proportional to what they are feeling, because they know the space they are in is not the appropriate space for that reaction, and because they also know they are being observed, and that how they behave in that moment will matter later in ways that are not yet fully predictable. That self-control, visible in every frame of those additional cameras, was the practical expression of a kind of awareness that Black people carry in public spaces, and that has a cost that appears in no recording but is absolutely real. At the customer service counter, the situation was presented to a store supervisor named Marcus, who was 32 years old and had 6 years of experience at that specific supermarket, and who listened to both versions with the expression of someone who has mediated enough customer disagreements to quickly recognize when he is facing something that is not a simple misunderstanding. Danielle presented the situation factually and sequentially. Christina presented a version that had evolved once more since the aisle, now including the suggestion that there had been a confusion about which cart belonged to whom, a narrative that the security footage made completely unsustainable, but that Christina presented with the confidence of someone who had not stopped to consider that there were cameras in the cereal aisle that had recorded every second of it. Marcus excused himself, went to the back office, and watched the relevant recording in less than 4 minutes. When he returned, his posture had changed in a perceptible way. Marcus asked that the cereal box be returned to Danielle immediately, offered a formal apology on behalf of the establishment for what had occurred, and informed Christina that the supermarket's general manager would be notified of the incident, and that depending on the assessment of that notification, she might be prevented from returning to the establishment. Christina heard this with an expression the customer service counter camera captured, and that was noticeably different from the expression she had carried throughout the entire interaction in the cereal aisle. It was the expression of someone who was beginning to understand, with a considerable delay relative to the moment when that understanding would have been useful, that the assumptions she had brought to that supermarket that afternoon were not assumptions the surrounding world was willing to validate in the way she had presumed they would be. The camera recorded that moment with the same indifference with which it had recorded all the others. It did not know what that moment would mean in the weeks that followed. But it was all there, preserved in high definition, waiting to be found. Danielle left the supermarket that afternoon with the yellow box cereal in her cart, and with something more she had not planned to take home, the absolute clarity that she was not going to let it pass. She had lived enough, had worked enough in environments where she needed to repeatedly prove competence to people who underestimated her before she opened her mouth, and had accumulated enough of that specific kind of fatigue that does not come from work, but from navigating a world that frequently treats her presence as something that needs to be justified. She knew how to recognize that fatigue, and she also knew, with the same clarity with which she recognized language development patterns in the children she treated, that ignoring what had happened in that cereal aisle was a way of saying it was acceptable. She did not believe it was acceptable, and she had the recording to prove she had reason not to believe it. The first call she made was still in the supermarket parking lot to her older sister, who was a legal assistant at a civil law firm, and who listened to the complete account in silence before asking one simple and direct question. Did the supermarket have security cameras in the cereal aisle? Danielle confirmed it did. There were cameras in practically every aisle of that establishment, and she had seen Supervisor Marcus go review the footage before returning the box and apologizing. Her sister paused briefly and then said that Danielle needed to formally request access to that recording before the system's automatic archiving cycle overrode it, which in medium-sized supermarkets normally happened between 48 and 72 hours after the recording was made. Danielle hung up the phone, went back into the supermarket, and asked to speak with the general manager. The general manager's name was Robert. He had been notified of the incident by Marcus before Danielle returned, and when she arrived at his office, he had already watched the recording. From the cereal aisle and the recording from the customer service counter, he was a 51-year-old man with 23 years of experience in the retail sector and with the capacity developed over that time to quickly identify when a situation had the potential to become something larger than a disagreement between customers. What he had seen in the recordings was unambiguous, and he knew that what Danielle was about to request was not only reasonable, but was the kind of request that any establishment with a sense of responsibility should grant without hesitation. Robert assured Danielle that the recording would be preserved and that she would receive a copy in an appropriate format upon formal written request, which he himself would prepare and date at that moment if she wished. She did. The document was prepared right there, with the date and time of that conversation, confirming that the supermarket acknowledged what had occurred, that there was video evidence of the incident, and that that evidence would be made available to Danielle through the appropriate legal procedures. Robert also confirmed, in response to a direct question from Danielle, that Christina was a registered customer in the supermarket's loyalty program and that access to the establishment could be suspended depending on the internal assessment of the incident. That detail, that Christina had a registered account and that there was a record of her information in the supermarket system, was information that Danielle's attorneys would use in the weeks that followed, in a way that Robert had probably not fully anticipated when he mentioned it. The decision to seek legal counsel was made that same evening after Danielle put her son to bed and sat in the kitchen, processing what had happened with the distance of a few hours and the silence that the end of the day allows. She had narrated the incident to her son in a way adapted for a 6-year-old, without the heavier details, but enough to explain why his mother had arrived a little later than promised, and why she had an expression that he had noticed and asked about, with the direct perception of young children. That conversation with her son, more than anything else that afternoon, had crystallized something. She was raising a black son in a world that had just demonstrated, once again, that the presence of black people in public spaces was treated as conditional in ways that the presence of other people was not, and she did not want the response she taught her son to be simply to let it go. The attorney she consulted 2 days after the incident specialized in discrimination cases at commercial establishments and had conducted similar proceedings before, none with video evidence as clear as what Danielle had secured through the document signed by Robert. When he watched the recording for the first time, his assessment was immediate and direct. The video showed a sequence of events that supported multiple legal allegations with direct evidence, without the need for inference or interpretation. There was the unauthorized removal of the item from the cart, documented at an angle and clarity that left no room for Christina's alternative version about cart confusion. There was the refusal to return the item after being confronted by the owner, documented in the same way. And there was Christina's behavior at the customer service counter, where she had presented a version of events that the recording directly contradicted, which added an additional layer of legal relevance to the material Danielle had preserved. The lawsuit was constructed over 3 weeks with a methodology that reflected both the clarity of the available evidence and the attorney's experience in cases where the opposing party tends to minimize what happened until the evidence makes minimization impossible to sustain. The central strategy was simple in its structure, but required precision in execution, presenting each allegation anchored in a specific and verifiable moment from the recording, in a way that any attempt by Christina to offer an alternative version of events would have to confront directly images that contradicted that version objectively and irrefutably. There was no room for subjective interpretation when the camera had captured every gesture, every movement, every second of the sequence that led from the cereal aisle to the customer service counter. The allegations were structured in 3 layers that reinforced each other progressively. The first was the most direct and the easiest to establish with the available evidence, unauthorized appropriation of personal property, because the cereal box was in Danielle's cart before any interaction between the 2 women, and the camera showed Christina removing that item without any request, without any authorization, and without any indication that she had confused the cart with her own because she did not have a cart. That point, that Christina had arrived in the aisle with a shopping basket on her arm and not with a cart that could have caused genuine confusion, was one of the elements the camera angle captured with enough clarity to be established as fact, without the need for any other corroboration. The second layer was more complex and more significant in terms of what the lawsuit was attempting to establish beyond the immediate incident. Danielle's attorney had researched Christina's public history carefully enough to identify a pattern that, although no prior incident had reached legal proceedings, was documentable through public records and statements from people who had had interactions with her in commercial spaces. There was a complaint filed at a coffee shop in the same area. There was a documented account in an online consumer group about an incident at an organic market. And there were at least 2 other people who, after the supermarket video began circulating, contacted Danielle's attorney spontaneously to report similar experiences. None of those cases had involved cameras. None had resulted in consequences. Danielle's case was different in both respects. The third layer was the one that most concerned Christina's attorney, who had been retained 2 days after she received formal notification of the lawsuit and who had requested access to the recording as a first step, probably expecting to find something that could be reinterpreted in a way favorable to his client. What he found when he watched the video was what anyone who watched it found: a sequence of events without ambiguity, captured at an angle and quality sufficient for each allegation in the lawsuit to have direct and verifiable visual correspondence. That third layer argued that Christina's behavior at the supermarket, considered together with the documented pattern of prior incidents and the specific nature of how she had treated Danielle, in contrast to how she had interacted with other customers visible in the recording, constituted racial discrimination in a public space. The kind of allegation that, in a legal context, requires evidence of pattern beyond the isolated incident, and that the lawsuit was building precisely that pattern with the pieces the research had assembled. Christina had a public presence as a lifestyle consultant, which meant the lawsuit and the evidence accompanying it did not exist only in the legal record, but also in the digital space where her personal brand had been built. When the supermarket video became public knowledge, which happened gradually but inevitably as the lawsuit progressed, and journalists covering discrimination cases in commercial spaces began making requests to access the recording, the reaction on the platforms where Christina had a presence was immediate and intense. The people who followed her as a lifestyle consultant were now watching the video that showed her removing an item from another woman's cart and refusing to return it. And the dissonance between the public persona she had built and the behavior documented on the supermarket security camera was large enough to produce the kind of reaction that digital platforms amplify with an efficiency that no crisis communication strategy can fully neutralize when the video evidence is that clear. Brands and commercial partners who had worked with Christina in her influencer capacity began distancing themselves with a speed that revealed how contingent those partnerships had been on the maintenance of an image that the video had compromised in a way that could not be reframed. 2 sponsors terminated, active contracts within a week of the video becoming widely accessible. An online course platform where Christina sold wellness content removed her materials from the catalog without a public statement, the kind of silent action that communicates more about the internal assessment of the situation than any formal declaration could. Christina's attorney began receiving communications from Danielle's attorney about the possibility of a settlement simultaneously, with the period in which Christina's professional consequences were becoming clear, and that simultaneity was not accidental. It was the result of a strategy that had anticipated that the legal pressure and the reputational pressure would feed each other in a way that would make the cost of going to trial progressively higher than the cost of resolving the case through an agreement that genuinely acknowledged what had been done. The settlement negotiations began formally on a Thursday afternoon, 5 weeks after that Tuesday at the supermarket. Christina's attorney had arrived at that first meeting with a proposal that his client probably knew, at some level they were not yet able to fully articulate, would be rejected. It was the kind of initial offer that exists not because whoever presents it believes it will be accepted, but because making a low offer is the only way to test how far the other side is willing to go, without prematurely revealing how much you are willing to concede. Danielle's attorney declined without an immediate counteroffer, which communicated to the other side that Danielle's team was not in a hurry and that the passage of time was not working in Christina's favor the way it sometimes does when the party being sued has more resources and more capacity to absorb the duration of a lengthy process. The absence of urgency on Danielle's side had a logic that went beyond legal strategy. Every week that passed without an agreement was a week in which Christina's professional consequences continued accumulating in a way that the legal process alone could not produce. The platforms where she had built her presence as a lifestyle consultant were undergoing a slow but documentable process of emptying, followers disengaging, partnerships ending, the architecture of a personal brand that had taken years to build being dismantled by the weight of a 3-minute video in a supermarket aisle. Danielle had not orchestrated that process. It had happened as the natural result of available evidence meeting an audience that had the capacity to evaluate it. But the existence of that process outside the courtroom created pressure on Christina that made each subsequent round of negotiations more favorable to Danielle than the previous one. The second round of negotiations produced a substantially more serious proposal, still insufficient by the criteria Danielle had established clearly from the beginning, but different enough from the first, to confirm that Christina's side had made its own assessment of the case's trajectory and had arrived at a conclusion about where it was heading, if not resolved. Danielle's attorney responded with a counteroffer that was precise in its terms, and that included, beyond a financial amount that reflected the harm caused, a set of non-financial conditions that Christina had resisted since the beginning of negotiations, but that Danielle had determined were non-negotiable. Those conditions were the core of what she had decided that night in the kitchen after putting her son to bed, and no time pressure or procedural argument had moved that determination a centimeter since then. The final agreement was signed on a Monday morning, 6 weeks and 4 days after the supermarket incident. The financial amount was kept confidential by a standard clause both sides had agreed to include, but the non-financial conditions were made partially public. Danielle's insistence, who had successfully argued that the public interest in transparency about what had been agreed, outweighed Christina's interest in having the details remain entirely private. Christina was required to complete a structured program of education on racial bias and discrimination in public spaces, with verification of completion by an independent entity and a defined deadline within which completion needed to be documented. That condition had been the most resisted by Christina's defense, probably because it was the most concrete in terms of what it required in acknowledgement, and for that same reason, it was the one Danielle had defended most firmly. Christina disappeared almost completely from the public digital space in the months that followed the agreement. The platforms where she had had an active presence were either inactive or operating with a minimal fraction of their previous engagement. The lifestyle consultant brand she had built over years had been sufficiently compromised by the video and its consequences that any reconstruction would require a degree of effort and time, she was clearly still assessing how to approach. There were no public statements, no redemption narrative attempts that sometimes appear in these cases, no movement suggesting she had processed what had happened in a way that produced anything beyond an awareness that there were consequences. Whether genuine reflection was happening somewhere beyond what the public record showed, there was no way to know. What there was a way to know was that a supermarket security camera had documented a 3-minute moment that had changed the trajectory of 2 lives in ways that were very different and very asymmetric. Danielle returned to work the week after the incident, returned to the supermarket 2 weeks later because it was the closest to her home, and
Integrity is a lifelong quest, and education remains your strongest asset. Thank you for tuning in and promoting institutional transparency.